will be considered as read and open for amendment. The chair is recognized for an opening statement. Our First Amendment rights do not change from one state to another, and our Second Amendment rights should not either. Law-abiding citizens should be able to carry a concealed firearm between states without worrying about conflicting state criminal laws or onerous civil suits. There are over 22 million concealed carry permit holders across the country. As of February 2025, 29 states have constitutional carry or permit-less carry laws. This means that a state does not require law-abiding citizens to obtain a concealed carry permit or license before carrying a firearm outside their home. Alaska was the first state to pass such legislation in 2003, with Louisiana and South Carolina most recently enacting constitutional carry just last year. In Vermont, consistently ranked as one of the safest states in the nation, no permit has ever been required to carry a firearm outside the home. Over the past 2 decades, the Supreme Court has issued several landmark decisions that have clarified what constitutes arms under the Second Amendment and the rights that the amendment protects. In the District of Columbia versus Heller, the court held that the term militia in the Second Amendment does not limit the protection to only those serving in our military. In McDonald versus Chicago, the court in 2010 explained that the Second Amendment is, quote, fundamental to the nation's scheme of ordered liberty and deeply rooted in the nation's history and tradition, and is therefore incorporated to the states through the 14th Amendment. Most recently, in New York State Rifle and Pistol Association versus Bruin, the court held in part that the Second Amendment protects the right to carry a handgun for self-defense outside the home. Before the Bruin decision, states fell into 2 categories when an individual applied for a concealed carry permit: shall issue states and may issue states. In other words, the simple desire for self-defense and the exercise of one's Second Amendment liberties were not always enough to satisfy the requirement in may issue states. The Constitutional Concealed Carry Reciprocity Act prioritizes the rights of law-abiding citizens to carry concealed firearms and the ability to travel freely between states without worrying about conflicting state codes or onerous civil suits. Under this bill, individuals with concealed carry permits or privileges in their state would be able to exercise those rights in any other state that allows concealed carry. This bipartisan legislation protects law-abiding citizens with nationwide reciprocity for concealed carry license holders and for residents of constitutional carry states, and passed the House on a bipartisan basis in 2017. I urge my colleagues to support H.R. 38. And with that, I would yield to the ranking member for an opening statement.
Thank you very much, Chairman Jordan. I oppose this legislation, which clearly has the wrong title in every element. First of all, this is not a reciprocity act. Quite the contrary, it has nothing to do with reciprocity. It abolishes reciprocity. States that right now want to engage in reciprocity arrangements with other states for concealed carry policies have that absolute right. 29 states, as the chairman says, have enacted some form of concealed carry reciprocity, exercising their powers under the Second Amendment and the 10th Amendment to negotiate reciprocal recognition agreements with neighboring states or all of the states. 9 states have chosen not to engage in any concealed carry reciprocity arrangements at all. Other states have permitless concealed carry for everybody. It's completely up to the states. In other words, good old-fashioned federalism is working. As Mr. Van Drew put it in our earlier discussion, concealed carry, he said, quote, is an individual state-by-state thing. But this bill would abolish this voluntary reciprocity right that the states currently enjoy. Amazingly, it would substitute for the judgment and the autonomy of each state legislature to set their own standards for who may carry a concealed firearm. The standards set only by the most lenient states, some of which have absolutely no standards at all. This bill is thus not about voluntary reciprocity. It's a nationwide mandate that our colleagues would impose on every single state, forcing them to accept the public safety risk decisions of states with the most permissive and, I would say, ineffectual gun safety laws. The word constitutional also sticks out like a sore thumb here in the title of this bill. Under the 10th Amendment and the Second Amendment, states have the police power right to choose concealed carry laws consistent with their own traditions, with American traditions and local public safety. This is the meaning of the Bruin decision in 2022 by the Supreme Court. States have exercised that power to determine for themselves who may carry a concealed firearm. For example, In my state of Maryland, we have stringent requirements around concealed carry. To get a permit, you must complete safety training, which includes instruction on self-defense, safe firearm storage, conflict de-escalation, and suicide prevention, and then you have to show that you can shoot accurately and handle a gun safely. All of that is perfectly constitutional. You must also store your firearms in accordance with Maryland's child access prevention law, and you must be at least 21. But there are 29 states that don't require a permit, don't require a background check, don't require safety training to conceal carry in most places, and some states allow people to be as young as 18 years old in order to participate. The bill before us today would allow someone who comes from one of these wide open, anything goes states to come to Maryland and carry a concealed handgun against the laws adopted by our people, by the representatives of millions of people. This nationwide straitjacket mandate makes it possible for dangerous people from one state to circumvent the laws of every state. For example, a person who cannot meet the requirements of Maryland's law, either because, say, they failed the live fire accuracy test or the background check, or because there are indicators that they're a danger to themselves or to other people, they would be able to shop around for a state and find one quickly whose standards they can meet. Then they could go anywhere. There are many states that previously required a permit to conceal carry and later dropped their permit requirement, but still issue optional permits so that permit holders can take advantage of reciprocity agreements and for other purposes. Arizona is one such state, and it makes no distinction between Arizona residents and all other U.S. citizens who apply for a concealed carry permit in Arizona. So under this legislation, a person who lives in Maryland but could not get a concealed carry permit in our state could go and get one from Arizona without ever setting foot in the state, and then suddenly be allowed to conceal carry in Maryland and every other state in the nation based on Arizona's law, even though they might have shown signs of dangerousness that disqualified them in our state. And to make this race to the bottom even more shocking, the bill specifically allows such a person to carry a concealed gun in a gun-free school zone. Understand that's what we're voting on, colleagues. It will give them the right to carry a concealed gun in a gun-free school zone, eroding not only state laws protecting school zones, but federal laws protecting students, teachers, and others in our public and private schools. The end result of all this is clear. We will be less safe. Studies have found that weak concealed carry laws are associated with a 15% increase in violent crime and 11% higher rates of homicide using handguns. Well, maybe some people don't like those studies. They've got their other studies. Fine, do it that way in your state, but don't impose it on my state. This bill would cause weak laws to have dangerous nationwide repercussions. This bill would almost certainly lead to nationwide increases in violent gun crimes and homicide, reversing the big progress we've made over the last 2 years, which Ms. McBath has talked about frequently. Given the increased public safety risks this legislation would impose on all of our states, law enforcement officers and law enforcement organizations across America are strongly opposing this legislation. So for all of those who were invoking those groups before, take note, they are against this. They know this bill would impose the lowest common denominator and drive that denominator into the sub-mezzanine basement level. If the bill were to become law, law enforcement would have to deal with even more armed individuals, and the bill restricts their ability to arrest or detain a person carrying a concealed weapon. Law enforcement officers who keep our community safe will be unable to know the permit requirements of 50 states and unable to determine whether someone is lawfully carrying, since the bill allows people to carry across state lines without any permit at all if they live in a permitless carry state. And any mistakes an officer makes in trying to enforce the law could subject that officer to a lawsuit under the bill. As a statement from 7 different law enforcement groups, including the International Association of the Chiefs of Police, the Law Enforcement Action Partnership, and the Association of Prosecuting Attorneys, says this mandate would, quote, severely erode public and officer safety and make it near impossible for law enforcement to confirm that an armed individual is carrying legally. This bill reflects a NRA agenda when it comes to public safety, more guns in more places. And if that really worked, the U.S. would be the safest place in the world for guns, but it isn't. There are about 400 million guns in our country, more guns than people, and the homicide rate here is nearly 25 times higher than other high-income countries, and the firearm suicide rate is nearly 10 times that of other similar countries. Finally, I must note that as our colleagues are advancing this dangerous legislation, the Trump administration is taking many more actions that make life easier for violent criminals. They not only pardoned more than 1,500 convicted insurrectionists, they're trying to roll back regulations designed to reduce gun trafficking and illegal gun sales. They're working to give convicted criminals the right to own a gun again. And just a few days ago, it was reported that they're going to cut as many as 1,000 agents, more than a third, from the Bureau of Alcohol, Tobacco, Firearms, or ATF. If they get their way with this legislation and these actions, we will not only have more people, including potentially convicted criminals, carrying a lot more guns in all of our states, but we're going to have drastically fewer federal agents left on the beat to investigate and prevent gun crimes. This is deadly serious. If we don't stop these policies, it will only be a matter of time before the homicide rate starts increasing as fast as the stock market is sinking. I urge my colleagues to oppose this truly dangerous legislation. I yield back to you, Chairman Jordan.
Without objection, all other opening statements will be included in the record. Chair now is recognized to offer an amendment in the nature of a substitute. The clerk will, amendment at the desk, the clerk will report.
Amendment in the nature of a
Without
substitute.
objection, the amendment in the nature of a substitute will be considered as read and shall be considered base text for the purpose of the amendment. Chair is now recognized to explain the amendment. This amendment simply adds the year to the title of the bill. There is no substantive change to the bill. I urge support for the amendment and yield back. The gentleman from Arizona is recognized.
Move to strike the last word.
The gentleman is recognized.
Thank you, Mr. Chairman. So this is a bill that's important. It's good. It's solid. I want to just make some comments because if you just heard recent comments from my friend across the aisle, you would think that this bill has nothing to do with federal land and law either, but it does. On page 4, talks about federal parks and lands and provides options or opportunities to carry there as well. But I have to speak as someone who has actually taken the classes in Arizona to become a certified concealed carry. You have to take the class where you learn about safety, care, and you actually shoot the weapon. You got to do that to become licensed to carry a concealed weapon in Arizona. You got to. But Arizona has another option. It is a constitutional carry state. That's the distinction, so because we believe that the Second Amendment extends to everyone in Arizona. But if you are a prohibited user, which Arizona does have prohibitions on carrying in certain places, you can't carry, you can't buy, you can't sell. But otherwise, we've got a constitutional carry. But I believe the gentleman sadly misunderstood Arizona's concealed weapon certification. And why did they keep that, even though you had constitutional carry? We kept it because we wanted to be able to get reciprocity in certain states. So if that was one of your deals and you wanted to carry in another state, you could apply and get reciprocity. That's why there's multiple avenues in Arizona. So, sorry, I think you were just a little bit off on that. I understand it. Might have been a little bit Byzantine to understand. With that, Mr. Chairman, I support this bill. And
Will the gentleman yield for a friendly question?
A friendly question, sure. Now, I've walked down that aisle before, though.
Well, my friend, the question is this: let's say someone doesn't qualify in Arizona, and they don't qualify at the shooting range, or they failed the Arizona background check. Do you think they should be able to go find one of these other states that have lower standards than Arizona, get qualified, and then come back to Arizona after you've already rejected them?
Well, if they are not a prohibited user, they're going to start carrying constitutional carry, which we allow. And by the way, Yeah, you can go either way, and so, yeah, they're going to be able to carry concealed.
Okay.
So they're not they're not going to leave the state, my friend, if they don't qualify to get the avenue, the certification for carried concealed weapon. They're not going to leave the state. What they're going to do is they're going to apply. They're basically going to. They're just going to start carrying because we have open carry. We got constitutional carry.
Okay, then I misunderstood your original statement. I thought you were saying that not anybody could do it. But so I had chosen Arizona, but maybe I got it wrong on the theory that somebody could be rejected in Maryland and then they could get certified in Arizona and then come back to our state after we've already not qualified them. Is Arizona not one of those states that would do that?
No, I mean, if you came in from Maryland and you wanted to carry, you could carry in Arizona, right? You could, but if you want to obtain reciprocity under current laws, you would apply, and you might not get your concealed weapon.
No, I got you, but I guess that my basic problem is that there are people who would be rejected in Maryland who can find another state that would qualify them, that have basically an open policy, and then they could come back to our state having failed our test.
But if they're living under constitutional carry law in Arizona, that doesn't mean that they're going to get reciprocity in any other state necessarily, although some states do allow reciprocity.
I thought that was the whole point of this bill. Isn't the bill to say
Well, that's the bill. That's
Okay.
you were trying to argue something as if it currently exists.
No, I was
that
saying...
would be erroneous because that isn't the way Arizona...
Then I stand corrected. All I was saying, if this bill passes, somebody could go to a state with the most lax laws in the country, get certified there for concealed carry, and then they'd be able to come back to our state. I think that's the whole purpose of the bill, is to override the states that have a more stringent test. And I think that's a major assault on federalism.
I think that the purpose of the bill is to recognize Second Amendment rights don't have boundaries.
Right. Gentleman's time has expired. Who seeks recognition? Gentlelady from Georgia.
Thank you, Mr. Chair. Mr. Chairman, H.R. 38, the Constitutional Concealed Carry Reciprocity Act, would make every one of our communities less safe. This bill forces states to accept the concealed carry standards of every other state. States that have strong concealed carry laws will be forced to suddenly have many more people in their communities who were eligible to carry concealed firearms in their state, even though their duly elected state legislators had crafted laws to prevent that. This is an obvious violation of states' rights. But what about the states with more lax laws? As my colleague from Maryland had just stated, in 2022, my state of Georgia removed its requirement that people who want to carry a concealed firearm must get a permit. You might think that in a permitless state like Georgia, this bill would do no harm, but it would. Georgia doesn't require a permit to conceal carry, but it does require you to be at least 21 years old. Our neighboring state of South Carolina allows those who are 18 or older to concealed carry. So this legislation would lower the age limit for concealed carry in Georgia over the will of Georgia voters. And the same would be true for the 17 other states that have permitless carry but require you to be at least 21 years old. This bill would even allow more concealed guns in school zones. This is just one small example of how this bill would allow more people to carry more guns in more places, eliminating each state's right to set its own standards. Critically, this legislation is not just a violation of states' rights, it's outright dangerous. This bill would effectively move the whole country to a permitless carry by allowing those with a right to permitless carry in their state of residence to conceal carry in any other state. But we know that permitless carry is associated with increases in murder and gun assaults. One study found that states that enacted permitless carry laws experienced a 27% increase in murders for the 3 years since its enactment, compared to 10% increase in nationwide murders over the same period. Another study found that states that weakened their permitting laws experienced a 9.5% increase in gun assaults in the 10 years after weakening their standards. The evidence is absolutely clear. Lax concealed carry laws increase violent crime, including murder, so this bill would likely increase violent crime and murder nationwide. The increased risk of lives lost to gun violence should be more than enough to end the debate on this bill, but the dangers go even further. More people carrying firearms more often also means more injuries. One study found that unintentional firearm injuries rose after states weakened their permitting standards. Another study found that people who carry firearms regularly are more likely to have their firearms stolen, and those stolen guns are then more likely to be used to commit further crimes. Given these significant threats to public safety, it's no wonder that law enforcement opposes this legislation. A letter to Congress from the National Law Enforcement Partnership to Prevent Gun Violence explains that this bill would leave law enforcement helpless to keep guns out of the wrong hands when a person claims they have a right to carry a concealed gun. The letter further explains that this bill is, and I'm quoting, an obvious step in the wrong direction that would sow chaos and uncertainty, making a cop's job harder and citizens less safe, end quote. I agree with law enforcement. This bill is a step in the wrong direction. Following the passage of the Bipartisan Safer Communities Act, we had historic drops in murder and violent crime. We should be working together to build on that success, to save even more lives from gun violence, and to prevent even more families from losing a loved one the way that I lost my son 12 years ago. Every day, we lose more than 100 Americans to gun violence. More than 3,000 people have died from gun violence already this year. We must do more to make our communities safer. But this legislation will instead make all of our communities more dangerous places to live. I strongly oppose this misguided bill, and I urge my colleagues to oppose it as well.
Will the gentlelady yield when you have a second?
I yield.
My question to you, Ms. McBath, is so the good people of Georgia have said you can get a concealed carry permit at age 21, but in South Carolina, they set it at 18. So now any 18-year-old who gets a concealed carry permit in South Carolina will be able to travel to Georgia. Exactly. And the officers are saying that's a problem because they're not going to know whether to ask them or not, and they can get sued simply for allegedly violating their Second Amendment rights, although there's no Second Amendment right for an 18-year-old to have a concealed carry permit, right? And so is that why the officers are so upset?
Exactly. That is my point. So I'd like to offer unanimous consent to enter into the record this letter, this statement. It's just absolutely, I find this deplorable that we would be loosening our existing gun laws, and I just strongly oppose this piece of legislation, and I yield back.
Without objection. Who seeks recognition? The gentleman from Tennessee is recognized.
Georgia. Surprised to see you at the wrestling national championships and getting a great crowd response that you got.
Yeah, thank you.
They all cheered for you.
Yeah, it was fun. Thank you.
You're welcome. I've got an amendment at the desk. Do I not have an amendment at the desk? Well, then she shouldn't have yielded. She should have put her amendment in.
She was getting recognized on the base call.
Who seeks recognition?
Ms. McBath.
Excuse me, Mr. Chair, I have an amendment at the desk.
Gentlelady can, clerk will report.
Chairman, I reserve.
Gentleman from California reserves point of order.
Amendment to the amendment.
Without objection, the amendment will be considered as read. The gentlelady from Georgia is recognized to explain her amendment.
Mr. Chairman, my amendment would prohibit a person convicted of committing a crime against a law enforcement officer from carrying a concealed weapon under the bill. According to statistics from FBI, 79,091 officers were assaulted while performing their duties in 2023. So it comes as no surprise that so many in law enforcement oppose this bill. As 7 national law enforcement agencies noted in a letter to this committee, the legislation could create a chilling effect in instances where police have to make split second decisions to protect others and themselves, and could deter police from taking appropriate and lawful action that may prevent someone from committing a serious and violent crime. Police officers need to be able to verify that people carrying concealed, loaded guns in public are legally allowed to carry them to keep themselves and their community safe. My amendment would at least ensure that officers don't need to worry that individuals who were previously convicted of committing a crime against law enforcement can carry a concealed weapon under this bill. I urge my colleagues to support this reasonable and important amendment to keep our law enforcement officers safe. And I yield back.
Gentleman yields back. Mr.
Chairman, I withdraw my.
Gentleman from California withdraws. I oppose the amendment. Someone convicted of a felony conviction is prohibited from exercising this right and carrying a concealed firearm already. And this amendment does not take proportionality and fairness into consideration under a misdemeanor conviction. This could easily create a conflict between distinguishing either a misdemeanor assault or impersonating conviction. So for those reasons, I would oppose the amendment. Who seeks recognition? Gentleman from California is recognized.
Mr. Chairman, I would certainly want to second the comments you made about why this was poorly written, perhaps. But additionally, when it says who has not been convicted of a crime under federal, state, or tribal or local land, 20 years ago, 30 years ago, somebody may have been convicted. If they've gone through the process of having their rights restored, this, as written, this, of course, would strike that ability. So the fact is that the federal government and or a state may have restored rights for good and proper reason, and yet this amendment would, because it's overly broad, would prohibit that. So I think you have a number of reasons. The chairman cited one. I would add that one in opposition, and hope we'll strike.
Will the gentleman yield?
Of course I would yield.
I have a question, because it's my recollection that this body just voted on a bill that makes any kind of, I think it was evasion or escape from a law enforcement officer a deportable offense. And here we are talking about an actual crime against a law enforcement officer, and somehow that should not be a disqualifying event, and yet just simply evading a law enforcement officer is grounds for deportation. And
I appreciate the gentleman's concern, although it really isn't germane. The fact is that a crime against a law enforcement officer is a felony. The chairman said it very well, and I added to it the possibility. But if you're concerned about immigration, I assure you, you'll have plenty of chances in this committee as we codify the president's many effective actions that have led to the streets of America being safer and the communities that I represent being safer. And with that, Mr. Chairman, I yield back.
Recognition. Gentleman from California is recognized.
Thank you, Mr. Chair. I support this amendment, and I oppose H.R. 38 for all of the reasons stated by my colleagues, and also because it is not going to keep law enforcement safe. Stevie Wonder can see that. It's not going to keep law enforcement safe. It will not bring down their anxiety. It will not give them less administrative headaches. And it is fallacious to say that this bill will make private citizens or law enforcement safer, or that any of these bills that we've discussed today will do that. The president wants to give states more authority. At least that's his argument for dismantling the Department of Education. And here you are with H.R. 38 trying to take away states' rights and the ability for law enforcement to do their job. We all here represent a district, so presumably we all know the needs of our communities. We know that they need Social Security and Medicaid and Medicare, and we know that they need their federal jobs. And we also know their safety risks, their appetite for firearm laws, the community's proclivities, and the capacity of our law enforcement agencies. And presumably, our states are making laws based on that alchemy of information. And H.R. 38 is going to turn all of that upside down. When I was in the California legislature, I was not making laws with Florida or New York in mind. I was making laws about California. And when I was making public safety laws, I was talking to our AG, our DAs, our probation officers, our sheriffs about the issues and the needs that they were dealing with, how they're operating their database, what other resources they need, what they have the capacity to do, what is allowed specific to California. And HR 38 says that none of that matters. It says that someone from another state can come into my state and say that they are governed by their state's laws in my states. That's like coming into my house and not obeying my house's rules. That is malarkey. And this is real stuff, because you're going to have people coming into your state hopped up on firearms and a bad attitude protected by the laws of their state when your state might legitimately not allow their behavior. And they can wreak all kinds of havoc because of the discrepancies in the law as it relates to firearms, the number of firearms, the types of magazines, different permits, all of that. And you are making law enforcement deal with that kind of chaos. It is going to create massive confusion for law enforcement, because states are going to have to figure out how to create a database to deal with this influx of folks who are coming in with their own ideas about their laws from their states. And we're all going to have to figure out how to reconcile those aversions. And that's just the paperwork. We're not talking about how this is going to harm officers, because that's also what's going to happen. And you're going to be tracking that in that HR 2240. I don't know about you, but when I talk to law enforcement, they say they don't want more guns on the streets. They are not okay with that. It increases their anxiety level, their stress level. It increases their calculation of danger. And they say repeatedly, they care about staying alive so they can go home and be with their families. But with HR 38, law enforcement officers across the country are going to be worried about people from outside their jurisdictions coming into their town, and they have no way to really navigate the nonsense that's going to be created because of this bill. The ranker said, this is like, instead of forum shopping for the courts, you got like forum hunting because of this bill. And let me tell you something, when a law enforcement officer has to check on someone that they don't know with a gun, they have to call in another officer, 2 officers become 4, and that starts jacking up and straining that municipality's resources, because more guns do not make people safe. You know, Ronald Reagan, and I don't support nothing about Ronald Reagan really, but he was the governor of California, and he changed gun laws in our state. I don't agree with why he did it. I don't agree with what he did, but he knew his state enough to go to the legislature to address the issues of that time. And when he became president of the United States, he did not transfer California's laws to the nation. HR 38 runs completely counter to 2240. And it is gaslighting, because on the one hand, you want more guns on the street, all connected to different permits and laws and behaviors of 50 states and territories and districts, and you're essentially terrorizing law enforcement. And then on the other hand, with HR 2240, you want to track their sanity and mental health. Oppose this bill. That's how you can protect their sanity and mental health. I mean, there are no standards. And you're going to defund or dismantle DOJ and ATF, and you're going to increase the onus on these cities and counties and states because now they have to track all these people and their guns. This is an unfounded mandate, and you go tell that to your city mayors and your county supervisors and your governors.
Time.
This is about hijacking state resources and meddling with state sovereignty and getting rid of common sense, and I oppose the bill and support the amendment.
The time of the gentlelady has expired. Who seeks recognition?
If nobody else, I seek recognition.
The gentleman from New York is recognized to speak on the amendment.
Thank you, Mr. Chairman. And I was disappointed not to have a more good faith colloquy with my friend from California on the, I think, hypocrisy of trying to defend law enforcement in the immigration context with non-felony crimes, but not protect law enforcement in the context of gun ownership and concealed carry. This is a very simple and I would imagine should be straightforward amendment that I'm surprised that my colleagues on the other side of the aisle who talk so much about backing the blue and supporting law enforcement think that a conviction, a non-felony conviction, which exists, so let's put felonies aside, a non-felony conviction against a law enforcement officer should not be grounds to exclude someone from carrying a weapon to a different state. So this is only about actually transferring a weapon from a home state to a different state and overruling that different state's laws. And here we are with a very straightforward amendment that is designed to protect law enforcement. And my colleagues on the other side of the aisle, once again, are not backing the blue. They, when it's convenient, want to talk very much about how much we back the blue, and if someone flees from a law enforcement officer, they obviously should be deported, and yet if someone actually commits a crime against a law enforcement officer, totally fine for them to have a gun.
Would the gentleman yield?
Yes.
I hear the gentleman's point. The problem is, as the amendment's written, or as I read it, if one were to get into a scuffle in a bar with a tribal policeman at the casino and were convicted of a misdemeanor, you would then, under this, be prohibited from this right, even if that was simply a misdemeanor for which you served no time. So when I said that it as written was very poor, I meant it. In fairness, I didn't mean to cut you off at all. It's just that the rights under the Second Amendment guaranteed in the Constitution are very different than the complete absence of rights for a foreign terrorist who are being deported. And so I can't really conflate the two.
All right, well, I'll reclaim my time, but, because obviously, you know, we like to create the hypothetical parade of horribles. Every single immigrant that comes into our country has to be a foreign terrorist. That's BS. We all know that. And the point is that you're happy to support someone running away from a law enforcement officer. That's not even a misdemeanor. They're running away from a law enforcement officer. They should be deported. And yes, somebody who assaults a police officer on tribal land and is actually convicted either by admitting it or by being convicted of a judge or a jury, yes, too bad. You don't get to benefit from the concealed carry laws. I think that's a very legitimate and reasonable minor restriction on Second Amendment rights, of which we, of course, all acknowledge that there are far too few, but there do exist some. And I guess with that, unless any of my colleagues, I yield to the ranking member.
Thank you for those trenchant insights, Mr. Goldman. You know, the reason why we've got all these law enforcement associations, like the International Associations of Chiefs of Police and the Association of Prosecuting Attorneys, weighing in heavily against this bill is because it makes an absolute hash out of state law. So more than 30 states don't require training in order for someone to carry a concealed weapon. And that's totally their constitutional right and authority under the 10th Amendment and the Second Amendment to decide that. But other states do require training. For example, my state requires training. Well, why should my state have to accept people coming in, maybe 18 years old, who've never been trained on a gun, who got a concealed carry permit? Nobody's been able to explain, as a matter of federalism, why that's something we should do. I hear people say, because we should have national Second Amendment rights, but there's not a Second Amendment right to do it, because the Supreme Court in Bruin said that's up to the state to decide. So some states allow 18-year-olds, some allow 21-year-olds. Why won't you allow my state to do our thing without subjecting us to everybody else's law? Thank you for yielding.
Gentleman yields back. Who seeks recognition? Gentlelady from California is recognized.
Mr. Chairman, I am persuaded by the arguments being made, and especially, our new representative in Los Angeles County, who just came from the state legislature and understands how this comes down. And in addition to listening to the police, I think it would be smart to listen to her. And I would also like to yield to the ranking member.
Thank you very kindly, Ms. Lofgren. You know, I hope everybody takes the time to read these letters from the police officers, who certainly would be supporting this amendment, although I can't say because I don't know they've seen the amendment, but at least this amendment says if you've been convicted for a crime, whether it's a felony or misdemeanor against a cop, no, you're not going to be able to get into somebody else's state with a lower certification. And God help us if one of those people does that, goes into another state and kills a cop or assaults another cop. I certainly would not want to be voting against that amendment in that case. But in any event, here's one of the things the officers are raising with this, and I'm reading it in their letters, and I recommend everybody read their letters carefully. There's no mechanism for police to verify out-of-state concealed carry permits, right? So you stop somebody who's, say, driving recklessly, and they've got a gun on them. Well, maybe that person is an 18-year-old who's got a permit from another state. Maybe they're from South Carolina. But if the individual's from a state that doesn't require a permit at all, and this is a permitless state, there may not even be a permit for law enforcement to verify in the first place. So how are they, can someone please tell me, and you know, I'm very happy to ask, how will law enforcement verify that that person actually is a concealed carry permittee or licensee from South Carolina or another state? And the officers, they've been calling me and they're sending these letters. They're saying, how are we going to make this thing work? I mean, they're not carrying Westlaw and Lexus with them in their police car. How are they going to look up what the state law is and whether this person who claims to be a permittee really is or not? And nobody seems to be able to answer that question. There's another problem they've been raising, which is the police have to make a split-second decision now whether to check whether this person is somehow permitted or not, whether they're a licensee or not, and they can be sued if they're interfering with the very broadly articulated Second Amendment right that we're hearing from our colleagues. So this deters police in my state from taking appropriate and lawful action to prevent someone from committing a potentially serious and violent crime. And nobody's able to explain why we need to do this or how, in fact, it's going to work. So at the very least, we've got to support Ms. McBath's amendment. Someone who has been convicted, right? Ms. McBath, I'm taking, that's correct. It's not charged with, which was the standard that our colleagues were using in a lot of those immigration contexts, but somebody's been convicted. In other words, they've been indicted, they've been brought into court, they've had all the benefit of counsel and due process, and they've been convicted unanimously by a jury of their peers for assaulting a cop, for attacking a cop. And now we're saying that person's got free reign to go all over the country if they're able just to get to the right state, or if they happen to live in a state which gives them free reign there. That's a remarkable thing. I thank the gentlelady for yielding, and I yield back to you, Ms. Lofgren.
Thank you, Mr. Raskin, and with that, Mr. Chairman, I yield back.
Yields back. Who seeks recognition? Question occurs on the amendment. You want to talk about the amendment there, Bill? Amendment?
Mr. Chair, may I say so?
Gentleman from California is recognized on the amendment.
I was listening to my colleague from California and realizing how California has gotten itself into the mess it's in with the kind of thinking that we see reflected by its state legislature over the past several decades, and why such an unprecedented exodus of people voting with their feet and leaving our state is now occurring. Just a couple of quick points. First of all, states do not have rights. States have powers. Individuals have rights, and a natural right that is enshrined and protected in our Second Amendment is the right to bear arms. Now, when Americans cross state lines, they should be able to take those rights with them. That's the spirit, if not the letter, of the full faith and credit clause of the Constitution. A driver's license issued by one state is valid in another. If you drive across a state line, you shouldn't be forbidden from driving any further because your license was issued by another state. A marriage license issued by one state is valid in another. You shouldn't be separated from your spouse or your children because you were married in another state. And with respect to the comments we've been hearing about law enforcement, I would commend to the Democrats the works of Sir Robert Peel, the father of modern law enforcement, who founded the doctrines of law enforcement in free societies, that the police are merely an extension of the citizens. In his words, the citizens are the police and the police are the citizens. It's true that these doctrines are no longer recognized by the far left because they are, the left is authoritarian at its core, but, and obviously they appoint some police chiefs of like mind. But the principles are sound. I used to work for the chief of the Los Angeles Police Department, Chief Edward M. Davis. He brought crime in Los Angeles down in the 1970s, even while it was ballooning 50% nationally in the 8.5 years he was chief. He was the father of Neighborhood Watch and community-based policing and the basic car plan. And at the core of his philosophy was that there's a natural partnership between citizens and the police, and that the Second Amendment was absolutely central to that partnership. And he proved that that worked by, through his tenure, leading the LAPD through its golden age. So I think a little more of that philosophy is important, and I'll yield back.
Gentleman yields back. The gentleman is yielded back. I'm sure we can get some time. I'll be happy to get.
Mr. Chairman.
Gentleman from New York is recognized.
Move to strike the last word.
Gentleman is recognized.
I yield to the gentlelady.
Gentlelady is recognized.
I had a question because the gentleman from California started talking about driver's licenses and marriage licenses. And I don't know if the gentleman is married, but I think if you get married in one state, you still have to get divorced in that same state. These things don't carry over. So states do have laws that you have to obey in that state and they don't transfer over. That's all I wanted to say. Thank you. I yield back.
I yield back.
From New York yields back. The question occurs on the amendment offered by the gentlelady from Georgia. All those in favor say aye.
Aye.
Those opposed, no. No. In the opinion of the chair, the noes have it.
We have a recorded vote, Mr. Chairman.
The ranking member requests a recorded vote. The clerk will call the roll.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Issa? Mr. Biggs? Mr. McClintock? Mr. McClintock votes no. Mr. Tiffany? Mr. Massey? Mr. Roy? Mr. Roy votes no. Mr. Fitzgerald? Mr. Klein? Mr. Klein votes no. Mr. Gooden? Mr. Gooden votes no. Mr. Van Drew? No. Mr. Van Drew votes no. Mr. Nels? No. Mr. Nels votes no. Mr. Moore? No. Mr. Moore votes no. Mr. Kiley? Mr. Kiley votes no. Ms. Hageman? Ms. Lee?
Sheriff, no.
Mr. Hunt? Mr. Fry? Mr. Grothman? Mr. Knott? Mr. Harris? Mr. Onder? No. Mr. Onder votes no. Mr. Schmidt? Mr. Schmidt votes no. Mr. Gill? Mr. Baumgartner? Mr. Raskin? Aye. Mr. Raskin votes aye. Mr. Nadler? Aye. Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Mr. Cohen? Mr. Johnson? Aye. Mr. Johnson votes aye. Mr. Swalwell? Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon? Ms. Scanlon votes aye. Mr. Neguse? Ms. McBath? Ms. McBath votes aye. Ms. Ross? Ms. Ballant? Ms. Ballant votes aye. Mr. Garcia? Mr. Garcia votes aye. Ms. Kamlager-Dove? Ms. Kamlager-Dove votes aye. Mr. Moskowitz? Mr. Goldman? Mr. Goldman votes aye. Ms. Crockett? Mr. Issa? Mr. Issa votes no. Mr. Tiffany? Mr. Tiffany votes no. Mr. Baumgartner? Mr. Baumgartner votes no.
Clerk will report.
Mr. Chairman, there are 10 ayes and 14 noes.
The amendment is not agreed to. Who seeks recognition? Gentleman from New Jersey is recognized.
Thank you, Mr. Chairman. I'm going to speak a little bit from the voice of experience here. As I mentioned earlier in the day, I have about 40 states, either through reciprocity or actually getting the permits. By the way, you want to talk about something prejudicial and wrong? You got to buy, in some states, these permits are very expensive. A lot of folks couldn't afford it. And in order to be safe in the carry, if you want to, as you travel around the country, it costs you a lot of money every year. And that in itself is unconstitutional and is wrong. You know, we hear about people carrying, and you know, in New Jersey years ago, before the Supreme Court ruling recently, it was virtually impossible to carry, virtually impossible. And I put a bill in the New Jersey legislature that would enable folks to carry in New Jersey, and I remember having a big argument with the Senate president because he said it was going to be the Wild West, and it would be scary, and it would be so terrible, and it would be horrible. Well, guess what? They had to, in New Jersey, comply like the rest of the country to the Supreme Court ruling. And now there's a lot of folks carrying. The crime has gone down. The incidents have gone down. It isn't the Wild West. It hasn't created a problem. That's number one. You want to talk about people carrying and being concerned? Speak to your local law enforcement. Go out in the streets, and I've done this in some of the cities in my district, and you go around with them, and we'll talk about guns, and they'll say, you know that person over there, that one there, these are where the drug deals are going down, these are where you can buy an illegal firearm, and we put them in jail. It doesn't matter because the judges release them. They're out over and over and over again. We're too permissive. We let people out that have committed serious crimes too early and too easily, and it's wrong. And they are carrying. There's people carrying no matter how restrictive you are because they're carrying illegally, and that isn't good. And you encourage illegal carrying when you do that. And statistics. People talked about statistics. Statistics can be deceptive. They can be manipulated. And it depends whose set of statistics you're looking at. And I haven't seen anything that's convinced me that anything terrible happens because of legal carry. Because guess what? If you're going to go and have constitutional carry or carry legally, you're not the one that's going out and committing crimes. It's the people who shouldn't have a gun. It's like, again, I'll use a New Jersey example. They said the maximum amount of ammo that you could have in a magazine would be 10 rounds, no more than 10 rounds. So I guess all the criminals, before they went out and held up a bank, before they went out and killed somebody, they went to their gun store and had the pin put in so they could only carry the 10 rounds. I'm being facetious. Come on. We're, again, inflicting pain upon legal gun owners that just want to protect themselves or are involved in the sport and don't do any harm. It doesn't make sense. My friends on the other side, what they really want to do is amend the Constitution of the United States. That's what you want to do. You want to deny Second Amendment rights. It is clear in the Constitution that we have this right. So I would suggest instead of arguing against these laws and Supreme Court decisions that you attempt to change the Constitution. I don't think you'll be very successful. Rights of illegals, that came up. I wanted to talk about that. Guess what, ladies and gentlemen? The rights of illegals that are here illegally in the United States of America are not exactly the same as the rights of people who are here legally, and that is true in any country around the world. Any country. You don't have exactly the same rights. So, yes, if you're illegal and you attack a police officer, you are going to be detained, go through due process, and then you're going to be deported. Also was said that we want to dismantle the Department of Justice, the ATF, the Attorney General's office. No, we don't. We want to make it better. We want to depoliticize it. We want to de-weaponize it. But we don't want to have happen what happened to innocent people before, whether it was ATF, whether it was the Department of Justice, whether it was the Attorney General. It was wrong. The bottom line is the way that it's going in the country right now, the way that it's existed for years, when you've got to buy all these separate permits with separate laws, not knowing what you could do. Good people Innocent people, number one, sometimes can't afford it. Number two, they get jammed up, just like the story I told earlier about the young lady, the nurse from Pennsylvania, who had a carry permit in Pennsylvania, crossed over the bridge in New Jersey, was stopped for, I think one of her taillights were out or whatever, was a good, honest person, never even got a speeding ticket. They wanted to put her in jail for 3 years, and fortunately the governor saved her. That's what's wrong. It's discriminatory, it's wrong, it's ineffective. This is a way to even the playing field and to do it in a way that helps the average American who wants to be able to carry a firearm. It's the Second Amendment. We're obeying for once the Constitution and the Second Amendment. I yield back.
Gentleman yields back, seeks recognition. Gentlelady from Georgia is recognized.
Mr. Chairman, I have an amendment at the desk.
Clerk will report. Gentleman from California reserves a point of order.
Amendment to the amendment in the nature of a
Amendment will be
substitute.
considered as read. The gentlelady from Georgia is recognized to explain the amendment.
Thank you. Mr. Chair, my amendment would prohibit a person subject to a restraining order for stalking, threats, or harassment from carrying a concealed weapon under the bill. A person who is subject to a restraining order from an intimate partner due to stalking, threats, or harassment is not allowed to purchase or possess firearms and so could not carry a concealed firearm under this bill. But the bill would allow stalkers and harassers who are not intimate partners to conceal carry firearms under this bill. This bill makes it easier for them to conceal carry a gun as they pursue the target of their stalking, threats, or harassment across state lines. Attempted murders of women are often preceded by stalking incidents. In fact, one study found that nearly 9 out of 10 cases there had been a stalking incident in the year leading up to the attempted murder. Further, most mass shootings are related to domestic violence, and responding to domestic disturbances often prove deadly to law enforcement officers. We cannot be responsible for enabling stalkers and abusers to follow their victims across state lines with concealed handguns. My amendment would prevent this by excluding these potentially dangerous people from being able to conceal carry under this bill. And I ask unanimous consent to enter into the record the role of domestic violence and fatal mass shootings in the United States 2014 to 2019.
Objection.
Thank you. And also, too, there's an article here that just further substantiate what we've been talking about. Firearms are by far the most common method used to kill police officers in the United States. From 2012 to 2021, 504 police officers were killed in the United States. Out of those, 456 officers were fatally shot with a gun, meaning that 90% of these homicides were perpetrated with a gun. From 2020 to 2021, the number of police officers fatally shot rose to 35%. Another statement here, police officers in the United States are more likely to be fatally shot in states with higher levels of gun ownership and weaker gun laws. A 2016 study concluded that police officers were 3 times more likely to be fatally shot in the states with the highest levels of gun ownership in the state than in the states with the lowest levels of gun ownership. The Giffords Law Center graded states based on the strength of their gun laws. States that received an F saw higher rates of police officers fatally shot from 2017 to 2021. I asked to enter into the record, weak gun laws are hurting police officers.
Without objection.
And also debunking myths the gun lobby perpetuates following mass shootings.
Without objection.
Mr. Chair, for the last 12 years, I've been fighting with just my heart and soul to really try to make this make this country safer, make our communities safer. And I promise you, I worked with law enforcement so readily. They were so dedicated to helping me find justice when my son was murdered. The least that we could do is try to prevent them from being hurt while they're in the line of duty. Any legislation that prevents their ability from being hurt or maimed or killed while they're on duty, we need to consider this. And concealed carry reciprocity, I mean, it's an open door that allows anyone who has any nefarious reasons or criminality, whatever it is that they intend to do, it puts our law enforcement in so much more danger. And I just don't understand why it's something so simple and so common sense we are fighting against. I am very grateful to all the law enforcement in this country. We owe them a great debt of gratitude for continuing to protect our communities and our homes and our lives. Why would you not want to do something that protects them from violence when they're on duty? And I yield back.
Generally yields back. I would oppose the amendment. I think it's redundant and repetitive. We have the Lautenberg Amendment of people convicted of domestic violence. We have the Bipartisan Safer Communities Act, which prohibits the purchase and possession of firearms for 5 years for people convicted in a court of a misdemeanor crime of domestic violence against a victim with whom they've have had a current or recent former dating relationship. And then when it comes to harassing or stalking, that is also covered. So I don't think this amendment is necessary. It's redundant. And would oppose the amendment. Who seeks recognition? The ranking member is recognized.
Thank you, Mr. Chairman. I want to commend Ms. McBath not only for this excellent and absolutely necessary amendment, but also for her magnificent activism. I'm not sure if all of our new colleagues know that Ms. McBath, because of the terrible personal tragedy she suffered, got into politics for that reason, to deal with this issue, and has been confronting the overwhelming power of the NRA and the gun manufacturers. And I'm sure she interprets this as just one more affront and insult today. But in any event, her amendment is excellent. It says that anybody who's subject to a court order restraining the person from harassing, stalking, or threatening an individual, which means that they have been doing that, does not have the benefit of this new nationwide mandate straitjacket on all of the states to admit people to come in on a concealed carry basis. The good chairman says this is redundant. It's already taken care of by existing law. And it is true that people who harass, stalk, or threaten intimate partners are prohibited purchasers and therefore would not have the benefit of this gaping new loophole that our colleagues want to create. But there are lots of people who harass and stalk and threaten other people who are not intimate partners. For example, people do that to politicians all the time. I think there's an Olympic athlete who was talking about being stalked today, Gabby Thomas. But there's also people who were once intimate partners or had some kind of relationship or got into a fight with somebody who stalked them. And so what Ms. McBath's amendment says, as I read it, is that if a court has ordered somebody to stop harassing, stalking, or threatening another person, whether or not they're an intimate partner, that person should not be allowed to cross state lines with a gun on a concealed carry basis, because that's a danger. Why are we opening up this Pandora's box in general? But at the very least, when it comes to people who've been convicted of crimes against cops or here who are harassing, stalking, or threatening another person, they should not have the benefit of that. And I'm happy to yield additional time to Ms. McBath if she's got further thoughts at this point.
Well, thank you to my colleague from Maryland. But there again, every day I meet people all across the country, and I'm meeting survivors every single day who've lost law enforcement, their loved ones. They're losing family members every single day. And when they ask me, why aren't you all doing anything? Why are you allowing these kinds of tragedies to happen over and over again? And I have to honestly say, I don't have an answer. I don't have an answer for you. All I can tell you is that the NRA gun lobby and my Republican colleagues refuse to consider keeping you safe, but expanding our gun laws, loosening our gun laws, and I don't have an answer for you.
Ms. McBath, if I could reclaim 1 second here, just an answer to that question. We heard the gentleman from New Jersey say, this is just about the Second Amendment. Nonsense. If it were about the Second Amendment, they wouldn't need this law. The Second Amendment would already take care of it. Of course it doesn't it doesn't follow from the Second Amendment. The Supreme Court said in the Bruin case, it's up to each of the states to follow within the contours of the doctrine that they set down. And so if the Second Amendment took care of it, they would just wipe out all the laws, but they've not been able to do that. So right now, there are a lot of states that have imposed meaningful, muscular standards for people to get guns. You might disagree with that, fine. In your state, you don't have to have that. But why should your state get to trump everybody else's state who thinks that this is a matter of public safety and they want to deal with it? So that use of the Second Amendment is completely inaccurate. You can't say, for example, when the courts have said that assault weapons can be banned or not according to the state, you can't say, oh, well, it's a Second Amendment right, therefore you can't ban assault weapons. That's just nonsense. That's a ridiculous way of talking about the subject, right? Like under the First Amendment, we have reasonable time, place, manner restrictions. You don't have to allow people to have a rally in front of other people's houses at 2 o'clock in the morning. You can't say, oh, yes, we have to allow that in every state now because that's what the First Amendment requires. That's what you're saying about the Second Amendment. It's a ridiculous and fantastical approach to a serious public policy problem. I want to thank Ms. McBath for her leadership on this. I yield back to you, Mr. Chairman.
Gentleman yields back. Gentlelady from Pennsylvania is recognized on the amendment.
Thank you. I do support the amendment offered by the gentlewoman from Georgia. It's a common sense amendment based on sound evidence, and it will save lives. Look, Americans across our country continue to live with the fear and grief caused by senseless gun violence that's taken the lives of too many of our loved ones, our neighbors, our friends. But Republicans here in D.C. want to roll back the progress we've made in states like Pennsylvania to keep weapons out of dangerous hands and off our neighborhood streets. This misguided bill that we're talking about right now, H.R. 38, would take a sledgehammer to our state's laws, forcing Pennsylvania and other states that have enacted stronger standards to allow individuals from any state with weak standards to carry concealed and loaded handguns in public. The data is clear. Studies have found that weak concealed carry laws are associated with an increase in violent crime and higher rates of handgun homicides. So Pennsylvania has enacted certain common sense laws to protect the public from some of the obvious dangers of concealed carry. In order to carry a concealed weapon in Pennsylvania, a person must have a valid license in their home state and be at least 21 years of age, because our legislature determined that's a minimum standard to protect our people in Pennsylvania. But 29 other states haven't enacted such common sense protections. They don't require a permit. So this bill would effectively overrule Pennsylvania's law requiring a permit. Pennsylvania says that people who pose a credible danger to the public can be blocked from having a concealed carry permit, but 35 states don't have that requirement. Pennsylvania blocks convicted stalkers from having concealed carry, but 23 states don't. Pennsylvania blocks abusive dating partners from concealed carry, but 20 states don't. Pennsylvania blocks people with multiple DUI convictions from concealed carry, but 33 other states don't. And Pennsylvania requires concealed carriers to be at least 21. 19 states don't. This bill would also allow concealed carry by out-of-state gun owners in areas that Pennsylvania does not, like elementary and secondary schools. So by subjecting Pennsylvania to this patchwork of laws from across the country, this law will make it harder for state and local law enforcement to do their jobs, because they're going to have to juggle what the laws are for every other jurisdiction and exempt out-of-state people from enforcement of those laws. And to add insult to injury, this bill would subject Pennsylvania police to lawsuit and money damages if they mistakenly enforce Pennsylvania's laws against people from states with weaker laws. So it's no surprise that this bill is opposed by law enforcement groups. Look, in the last couple years, we've seen a dramatic decrease in gun violence across Pennsylvania as a result of common sense policies that keep firearms out of the hands of people who shouldn't have them. Now is not the time to go backwards when it comes to reducing gun violence. There's plenty of work to do. Americans deserve a Congress that does its job and puts forward solutions to keep people safe, not one that turns back the clock. I strongly oppose this bill, and I yield back. Sorry, I would yield to the ranking member.
Thank you, Ms. Scanlon. I just want to say our colleagues should consider this when you're thinking about voting against the amendment to exempt from the benefit of this great new mandate on all 50 states in America people who are harassing, stalking, or threatening other individuals, look at who's been doing that. The Judicial Conference has been complaining about the fact that they are being threatened, intimidated, and stalked by people across the country. In the last several decades, 4 federal judges have been murdered. Several more have seen their own family members killed at the hands of defendants and court litigants, and many others have been enduring repeated and lurid violent personal threats and intimidation and stalking. We have seen more than a tripling of violent threats against judges over the last decade. So now we're saying, all right, you've got a strong state like Pennsylvania, which says we are going to be very careful about who gets concealed carry so that criminals and dangerous people are not sneaking in. But suddenly we're going to impose this nationwide straitjacket on Pennsylvania and say they've got to accept the states with the weakest laws in the country, where basically anybody can get concealed carry and those people can enter the state. And what if one of them is nursing a grudge against a particular judge or a particular justice? Look where we are in America right now. And we're actually talking about not giving an exception to this law for people who are under a court order to stop them from stalking somebody. In other words, it's been proven in court they're threatening or intimidating, stalking somebody, and you guys want to make this part of this new nationwide law. It's incredible to me. Thank you. I yield back.
And I yield back.
Gentlelady yields back. The gentleman from Georgia is recognized on the amendment.
Thank you, Mr. Chairman. I rise I'm in favor of the amendment, and I would ask for unanimous consent to enter into the record a article, NBCnews.com, entitled "Olympian Gabby Thomas says a group of men have been following her at airports."
Without objection.
And, Mr. Chairman, this is an article that talks about a woman who is attractive, who is harassed and stalked at airports when she is traveling. And these can be people who follow her, or they can be people who just might happen to see her. She is an attractive woman. And the problem here is that we have non-intimate partner stalking. We have people who she could get a court order against to stop them from following her and stalking her, but because they are not considered to be intimate partners, then they would be exempt from the prohibition in the underlying legislation that would prohibit them from being able to conceal carry in any particular state. And so that's a loophole that this amendment would cover, which is why I support this amendment. And with that, I will yield back.
Gentleman yields back. Does anybody else seek to be recognized? This amendment. Hearing none, the question occurs on the amendment offered by the gentlelady from Georgia. Those in favor say aye.
Aye.
Those opposed say nay. No. Opinion of the chair, the nays have it. Okay. Recorded votes. Recorded vote's been requested. Clerk will call the roll.
Mr. Jordan. Mr. Issa. Mr. Issa votes no. Mr. Biggs. Mr. McClintock. Mr. Tiffany. Mr. Massey.
No.
Mr. Massey votes no. Mr. Roy. Mr. Roy votes no. Mr. Fitzgerald. Mr. Klein. Mr. Gooden. Mr. Van Drew. Mr. Van Drew votes no. Mr. Nels. Mr. Nels votes no. Mr. Moore. Mr. Moore votes no. Mr. Kiley. Ms. Hageman. Ms. Lee. Mr. Hunt. Mr. Fry. Mr. Grothman. Mr. Knott. Mr. Harris? Mr. Onder? Mr. Onder votes no. Mr. Schmidt? Mr. Schmidt votes no. Mr. Gill? Mr. Gill votes no. Mr. Baumgartner? Mr. Raskin? Mr. Raskin votes aye. Mr. Nadler? Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Mr. Cohen? Mr. Johnson? Mr. Johnson votes aye. Mr. Swalwell? Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon? Ms. Scanlon votes aye. Mr. Neguse? Ms. McBath? Ms. McBath votes aye. Ms. Ross? Ms. Ballant? Mr. Garcia? Mr. Garcia votes aye. Ms. Kamlager-Dove? Ms. Kamlager-Dove votes aye. Mr. Moskowitz? Mr. Goldman? Mr. Goldman votes aye. Ms. Crockett? Mr. Biggs? Mr. Biggs votes no. Mr. Tiffany? Mr. Tiffany votes no. Mr. Fitzgerald? Mr. Fitzgerald votes no. Mr. Baumgartner? Mr. Baumgartner votes no. Mr. Klein? Mr. Klein votes no. Mr. Grothman? Mr. Grothman votes no. Mr. Kiley? Mr. Kiley votes no. Mr. Gooden? Mr. Gooden votes no. Mr. McClintock votes no.
Are there any members who wish to vote who haven't voted? Clerk will report.
Mr. Chairman, there are 9 ayes and 18 noes.
The nays have it. Who seeks recognition?
Mr. Chairman,
Gentleman from New York is recognized.
I have an amendment at the desk.
Clerk will report the amendment.
Amendment,
Mr. Tiffany reserves a point of order.
amendment to the amendment in the nature of a substitute to H.R. 3.8 offered by Mr. Nadler of New York.
Without objection, the amendment will be considered as read.
Mr. Chairman,
Gentleman's recognized.
thank you. Mr. Chairman, this nation is awash in guns, and gun violence is ravaging our communities. Each day, more than 300 people are shot, including more than 20 children. And each day, more than 100 people die from these wounds. But instead of tackling this epidemic of gun violence and bringing forward sensible gun safety legislation, House Republicans want to put more guns in our communities. Not only that, they want to overrule the reasonable restrictions that states have put in place to protect their citizens. This legislation is an affront to federalism and a threat to public safety. The states have made carefully crafted judgments about who may carry concealed firearms in their states and under what circumstances. This bill, however, would completely override those decisions and would endanger the citizens of the states whose laws will be overruled. This legislation would eviscerate the core public safety determinations that each state makes concerning eligibility to carry concealed weapons. Whether it is requirements for periodic training, certifications of good character, minimum age requirements, or other standards, each state chooses what best fits the needs of their own citizens and best protects the safety of their communities. For example, 13 states have made the deliberate determination to bar violent misdemeanor offenders from possessing guns at all. This policy is associated with a 21% reduction in intimate partner homicide and an 18% reduction in overall homicide. Other states will not issue concealed carry permits to individuals convicted of various violent misdemeanor offenses. Depending on the state and the circumstances, this may include people convicted of sexual battery, aggravated assault, and strangulation. Under this legislation, however, those states would be required to allow such offenders to carry a concealed weapon if they have a valid license from another state. That is an outrageous intrusion on states' rights and an unacceptable threat to public safety. My amendment, therefore, would exempt from this bill anyone who has been convicted of a violent misdemeanor. It would ensure that such offenders may not carry a concealed weapon in a state where their conviction would otherwise disqualify them from carrying in public. Without my amendment, this legislation would gut these states' public safety decisions and would subvert the will of their citizens. It would allow violent offenders to seek permits from those states that will happily grant them, and then to take those permits and legally carry guns in states that would otherwise bar them from doing so. We know from research that a history of misdemeanor convictions predicts future criminal activity for gun purchasers. One study showed that buyers with at least one conviction were more than 7 times more likely to be charged with a new crime compared to gun buyers who do not have that criminal history. In fact, if you look at men with at least 2 violent misdemeanor convictions, they are 10 to 15 times more likely to be charged with gun crimes or violent crimes after that gun purchase. To those states that have made the reasonable decision not to allow individuals with such violent criminal history to carry such a concealed weapon, this bill overrides that decision. We should respect the public safety determination of those states and make sure that these violent offenders cannot use this legislation to circumvent their laws. I urge adoption of the amendment. Now yield back the balance of my time.
I thank the gentleman. Does anybody seek to be recognized on the amendment? Mr. Tiffany withdraws his point of order. Although I appreciate the gentleman's offer of an amendment here, an individual's constitutional right to protect themselves and their loved ones should not be stripped away for a misdemeanor. And by the way, the Gun Control Act of 1968 already prohibits an individual convicted of a felony or a crime punishable by a year or more from either purchasing or possessing a firearm. If you can't purchase or possess it under the law, how would you carry it under the law? This amendment is therefore redundant and unnecessary. Furthermore, federal law also prohibits an individual convicted of a misdemeanor of domestic violence from possessing or purchasing a firearm. So again, this amendment is therefore either redundant or unnecessary. I yield back.
May I be recognized?
Yes. Gentleman from New York is recognized.
Thank you, Mr. Chairman. I appreciate that convicted felons are not allowed to purchase a firearm and therefore are not allowed to carry a firearm. I appreciate that there are some misdemeanor domestic violence crimes that prohibit anyone from purchasing a firearm, but that's not what this amendment does. So by bringing up those facts, you are missing the point. The point here is there are violent misdemeanors. There are assaults. There are other crimes of violence that do not carry a penalty of 1 year or more. And again, it's bewildering to me that you all are so dug in against amending or changing a bill that you unilaterally drafted, even if the amendments are so clearly and obviously reasonable and they're not covered by existing law. Are you really telling me and telling the American people that someone convicted of a violent misdemeanor should not only be allowed to carry a gun in some states, but should be allowed to bring that concealed weapon to other states that would have prohibited that person from obtaining a gun? It's insanity. And I'm so tired of the hypocrisy when it comes to states' rights. Just be consistent. If you're going to tell us that you don't think that states should oversee any laws, that the federal government should be able to dive into whatever policy areas it wants to, great, fine. Then we know the playing field that we're on. And we're happy to have that conversation. But you can't pick and choose when states' rights apply and when they don't. Yet you do consistently. This is such an obvious common sense amendment. And then to misdirect everyone by saying it's redundant when it's not is a bad faith argument. So at least let's have a good faith discussion about this and explain to us why you oppose those convicted, not arrested, like the Lake and Riley Act, convicted of violent misdemeanors should be allowed to carry concealed weapons into states where they would otherwise not be allowed to. If a single Republican member can explain a good rationale that does not rely on some blanket Second Amendment right, when we all know that the Second Amendment right is not absolute, and we are not, Mr. Van Drew, saying that there is no Second Amendment right. We are not sitting here telling you that the Second Amendment doesn't exist. We are simply putting common sense restrictions to prevent senseless deaths, senseless gun deaths that happen over and over and over again in this country at a rate so far above any other country that it is not mental health. It's just baffling that you're so partisan that you can't even look at an amendment in any kind of objective manner and say, you know what? We didn't include this in our bill, but this makes sense. Let's vote it in. I yield back.
Gentleman yields back. Gentleman from New Jersey is recognized.
Thank you. And to my friend from New York, look, there is a Second Amendment. There are Second Amendment rights. This legislation that we are debating today abides with those rights, is within those rights. And I'm still going to maintain what I said before. If you don't like it, I understand that. I even respect it. But then you have to change the Constitution. And to speak to some of the issues that you brought up, if you notice a hesitancy on this side of the aisle, there is a reason. Because the reality is, and the truth is, that many good people who are not lawbreakers, and there's many, many examples where they get in trouble for the most minor of incidents with a gun. And I don't mean holding somebody up or threatening somebody or anything like that, but crossing a state line by accident and not having the permit, by not really, was another example in our state of a farmer that had a shotgun that I think was an inch too short that he just used on his farm and didn't use for anything else. Never had any problems, never had any convictions, never had any arrests, never threatened anybody, got in trouble. The honest to God truth is that there are really good people who got in trouble because of this patchwork system that we have in place that doesn't abide by the Constitution of the United States of America. And you can try to point out little examples here or there or say that this is why we should do it. And again, you're free to have that argument, have that discussion, have that colloquy, have that debate. But the reality is, it is the Second Amendment. And if you want to change it, then you have to amend the Constitution. And the second point I want to make that is important and I think has been overlooked, we have a great deal of reciprocity already in the country. I mentioned before that I can carry in about 40 states. A lot of those are reciprocity states, states that recognize other states already across the country that have all different kinds of regulations and rules, but they recognize them. Because to be honest with you, it is tricky business. When you are a law-abiding, good person that never did anything but simply wants to carry, you can get in trouble and really have big problems. Just what you're mentioning before, the 18 and 21. Some states are 21, some states are 18. God forbid you're 18 years old and you go into a state that is 21 and you get, not realizing that, the way it currently is, you get caught, you're in deep trouble. You broke a gun law. Then you've got on your record you broke a gun law. And in some states, forgive me, but the states that tend to be more left, more liberal, more Democrat, whatever you want to say, that's the person who ends up going to jail. That's the person who ends up getting in trouble, not the person who knowingly, was convicted of a crime or has perpetrated a crime, has done something that we would all find distasteful, possibly evil. There, we're showing more laxity and we're trying to help them and we're trying to be, more understanding of what it is. But for good people that have done nothing wrong, and it has happened and it continues to happen in this country, they get in trouble because they get jammed up on all these technicalities from state to state. Some states you can go in a restaurant, other states you can't. Some states you can do one thing, other states you can't. And then I don't know how good you are. If you're traveling across the country or driving through multiple states, it can be very complicated, and good people really can be hurt by overly zealous.
Will the gentleman yield for a question?
I will yield.
I find it interesting that you noted that a number of states provide reciprocity, which seems to indicate that states are well aware of that possibility, and some have decided to provide it and some have not. Why is it appropriate for the federal government to come in and overrule the state's considered decision as to whether or not reciprocity should be given?
I will reclaim my time because I don't think they're overruling anything. They are just making sure that nationally we abide by the Constitution of the United States of America. And that provision, the Second Amendment, is part of that Constitution, and we need to make sure that the Constitution is fulfilled. And that's the answer to that.
Would the gentleman yield? Would the gentleman yield?
Yes, I will yield back.
I would suggest if the Democrats think you should be deprived of your Second Amendment rights for a bar fight or for shoving somebody, for a misdemeanor conviction that involves, quote, violence, they should try the next time they're in the majority to update Section 922G, which enumerates all of the reasons you would become a prohibited person and prohibited from purchasing a firearm. And yields back. Gentleman's time has expired. Now recognize the gentlelady from Pennsylvania.
Thank you. Frankly, I have to say I'm a little surprised that our Republican colleagues are opposing an amendment that would prevent violent criminals from carrying concealed weapons, because that's what this amendment would do. It's a well-drawn amendment that would address a loophole that we have here. Mr. Massey is correct that felonies are covered already, and he's also correct, or I can't remember if he mentioned, that misdemeanors regarding crimes of domestic violence are covered, but these aren't the only violent misdemeanors. For example, in Pennsylvania, it's a misdemeanor to obstruct or impair law enforcement by force or violence or physical interference. So if someone is convicted of that violent misdemeanor, obstructing a police officer, they would still be allowed to, they would not be allowed to have a concealed carry. I think it's a common sense law that we should all be able to agree upon, and I would support the amendment. And just with respect to Mr. Van Drew's suggestion that somehow this amendment is taking away someone's Second Amendment rights, it's not saying they can't own a weapon. It's just saying they can't carry it in a concealed fashion. I would yield back.
The gentleman yields back. The gentleman from California is recognized.
Thank you. I have a question for the gentleman from New York, if he, and will yield if you're inclined to answer, which is that, can you give me an example of any state where CCW holders commit homicide or any other crime at a rate greater than the general population?
I don't think I understand your question.
Can you give me an example of any state where CCW holders commit homicide or any crime at a rate that is higher than the general population does?
I don't have that data in front of me, but I'm happy to look into it.
Well, because you made some claims about how if we allow this policy, it's going to unleash criminals or, violence upon the rest of the country. It would seem for that, maybe you'd have a point if there was some state out there where, its standards are so low that you have all kinds of criminals getting their hands on CCWs and committing terrible crimes. But to my knowledge, there is no example of any such state. To the contrary, the data shows that CCW holders are usually, 10 times less likely to commit crimes, including violent crimes, than the general population.
Will the gentleman yield?
Sure.
I would just point out the data on gun violence in states that have lax gun laws and states that have strict gun laws, because what you will find is there's a direct correlation to gun violence and the amount of gun violence in the states depending on how strict and restrictive their gun laws are.
Okay, but that's not the question. On this bill, we're talking about CCW holders. So if you saw reliable evidence that CCW holders are much less likely to commit acts of violence or other crimes than the general population, would that change your opinion on the merits of this bill?
No.
All right, I yield back.
The gentleman yields back. Who else seeks to be recognized?
I'd seek unanimous consent.
The gentlelady has unanimous consent. Request is recognized.
I would ask unanimous consent to enter into the record an analysis of the gun violence archive data from the Trace titled "Shooting Deaths Were Higher in Most States After Permitless Carry."
Without objection.
And also ask unanimous consent to enter into the record an article by Chip Brownlee titled "Permitless Carry Will Deter Shootings." Proponents said, "That's not what happened," published by the Trace on August 9, 2024.
Without objection. The gentleman from Virginia is recognized.
I move to strike last word.
Gentleman is recognized.
Thank you, Mr. Chairman. I'm glad we're having this debate tonight because we were all sent here by our constituents to represent the views of the majority back in our districts. In my district, the majority of constituents in my district sent me to Washington, just as they sent me to Richmond before that, to protect these constitutional rights. The constitutional rights, including the Second Amendment, which actually we can improve by passing this bill, which would allow people to cross state lines and still have those Second Amendment rights protected. It was an honor for me in the State House to chair the Committee on Militia, Police, and Public Safety, one of the oldest committees in the Virginia General Assembly, but it was a principle of that committee and of the Virginia House to defend those Second Amendment rights. We consistently reported out constitutional carry bills, and in Virginia we do have a concealed carry law, but we respect the rights of other states that if they have other laws, that they should be able to come into Virginia, that there should be some kind of reciprocity, and that individuals who are legally permitted to carry a concealed firearm in other states should be able to do so in other states. At the core, this bill is affirming just a simple truth: the right to self-defense, the right that is protected by our Second Amendment, should not end at a state border. The Second Amendment is not about gun violence. It's about your right to protect yourself, your family, your property in the way that you see fit, leaving to the individual the decision as to how to protect themselves. I hear a lot from the other side about how they make the decisions to keep people safe and how they know best as to how to keep Americans safe with more gun laws, more government intervention, and more government oversight over the rights of people to defend themselves. The people on this side of the aisle, and quite frankly, the side that got more votes in last November, believes in the power of the individuals to make those decisions. And that power was not granted to them by government, but by God, and that it was enshrined in the Constitution by the founders to protect that God-given right. So just as the First Amendment right to free speech doesn't change from state to state, we shouldn't burden lawful gun owners with an inconsistent or confusing patchwork of concealed carry laws. Some would argue that the bill jeopardizes public safety, but the facts don't support that claim because concealed carry permit holders, as has been stated, are the most law-abiding citizens in America. Criminals, by definition, don't follow the law, but law-abiding gun owners do, and they shouldn't have to risk legal jeopardy simply for exercising their constitutional rights while traveling to another state. So I support this important legislation, support the principles that are enshrined in the Constitution, and I hope that we would defeat this amendment and pass this bill.
Will the gentleman yield for a question?
Gentleman yields back. Who seeks recognition? Gentlelady from California is recognized on the Merlin-Nadler amendment.
Thank you, Mr. Chair. I'd like to yield to my colleague from New York.
I thank the gentlewoman from California. We're focused right now on concealed carry permits. At least that's what my friend from California and Mr. Klein were just talking about. But this bill, as I understand it, you can correct me if I'm wrong, would apply to states that don't require permits to carry concealed weapons. And based on, this data that we just entered into the record, there are 20 states that do not require permits to carry weapons. The data on that we just introduced into the record shows that the majority of states that enacted permitless carry between 2015 and 2022 saw significantly higher shooting death rates after the implementation. So, and I'm willing to be corrected here if I'm reading this incorrectly, but what I understand from this bill is that if you are in a state that allows an individual to carry a concealed weapon without a permit, you will then be permitted to carry a concealed weapon without a permit in every state in the country. And so, while I appreciate the gentleman's pointing to the additional, the data that shows that those who have concealed carry permits are safer with guns, we're talking about many people, 20 states that don't even require those permits. And now, essentially, the entire country, it will become a permitless country. And anybody who can go to one of those 20 states and get a permit can now go around the United States in contravention of state laws that are successful, those state laws that restrict concealed carry have lower gun violence rates, and now we're just undoing that with this bill. Correct me if I'm wrong, but that's how I read it. And so this conversation about concealed carry permits is a complete red herring. That's not even what we're talking about here. I yield back to the gentlelady.
Gentleman yields back. Question occurs on the amendment from the gentleman from New York. All those in favor say aye. Aye. Those opposed, no. No. In the opinion of the chair, the noes have it.
Recorded vote.
The roll call vote being requested on the Nadler amendment, the clerk will call the roll.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Issa? Mr. Issa votes no. Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Mr. Tiffany? Mr. Tiffany votes no. Mr. Massey? Mr. Massey votes no. Mr. Roy? Mr. Roy votes no. Mr. Fitzgerald? Mr. Klein? Mr. Klein votes no. Mr. Gooden? Mr. Van Drew? Mr. Van Drew votes no. Mr. Nels? Mr. Nels votes no. Mr. Moore? Mr. Moore votes no. Mr. Kiley? Mr. Kiley votes no. Ms. Hageman? Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Fry votes no. Mr. Grothman? Mr. Knott? Mr. Harris? Mr. Onder? Mr. Onder votes no. Mr. Schmidt? Mr. Schmidt votes no. Mr. Gill? Mr. Baumgartner? Mr. Raskin? Mr. Raskin votes aye. Mr. Nadler? Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Mr. Cohen? Mr. Johnson? Mr. Johnson votes aye. Mr. Swalwell? Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon?
Aye.
Ms. Scanlon votes aye. Mr. Neguse? Ms. McBath? Ms. McBath votes aye. Ms. Ross? Ms. Ballant? Mr. Garcia? Mr. Garcia votes aye. Ms. Kamlager-Dove? Ms. Kamlager-Dove votes aye. Mr. Moskowitz? Mr. Goldman? Mr. Goldman votes aye. Ms. Crockett? Ms. Crockett votes aye. Mr. Fitzgerald, you are not recorded. Mr. Fitzgerald votes no.
How am I recorded?
Mr. Knott, you are not recorded.
No.
Mr. Knott votes no. Mr. Grothman, you're not recorded. Mr. Grothman votes no. Mr. Baumgartner? Mr. Baumgartner votes no. Mr. Gooden? Mr. Gooden votes no.
Clerk will report.
Mr. Chairman, there are 10 ayes and 20 noes.
The amendment is not agreed to. Who seeks recognition?
Mr. Chairman.
Gentleman from Kentucky is recognized.
Wait, I have an amendment at the desk.
Clerk will report.
Substitute for the amendment in the nature of a substitute to H.R.
Ranking
38,
member reserves a point of order.
offered by Mr. Massey.
Without objection, the amendment will be considered as read. The gentleman from California, or excuse me, from Kentucky is recognized to explain his amendment.
Mr. Chairman, I appreciate H.R. 38, the Constitutional Concealed Carry Reciprocity Act. I intend to vote for it, but and when it was first drafted, I think it was more complete. But what has happened is we've had a Supreme Court decision and we've had some activity by the states, sort of changes the nature of H.R. 38. What is that activity? Well, 29 states are now constitutional carry. This will address Mr. Goldman's concern. 29 states are now constitutional carry. H.R. 38 sets up a situation where if you are in a state like Kentucky that has constitutional carry, and you travel to a state like California, which does not have constitutional carry, I have, in some ways, more rights to carry a gun in California than does a California resident, under the framework that H.R. 38 would establish. Now, those were just a few exceptions here and there to H.R. 38 when there weren't that many constitutional carry states. But now there are 29 constitutional carry states. What else has happened? Well, the Supreme Court decision of Bruin says that every state now has to issue a permit. So if I'm from Kentucky and I have constitutional carry, it means I now have constitutional carry in every state under H.R. 38. There's also sort of this other issue that Mr. Goldman, or actually Mr. Nadler's amendment got to that my amendment solves, because my amendment, by the way, is just a statement of a bill that I have offered, which is national constitutional carry. And what my bill says is that if it is legal for you to own a gun in a state, then it is also legal for you to carry that gun in that state. It doesn't impose on California a new set of gun rules or a new category of people who are eligible or not eligible to own a firearm. It just says, if the state of California has decided that you can own a gun, that you are able to own a gun, and that you meet those qualifications, and that the gun is one that the state of California approves of, then the state of California has to let you carry that gun. It doesn't provide any more rights to somebody from Kentucky and California than a person in California has in California, which is one of the problems with H.R. 38, is H.R. 38 gives me, the person from Kentucky, more rights in California than Mr. Kiley has in California. So we just solved this by doing constitutional carry for the whole country. If we're able to impose H.R. 38 and get half pregnant, surely we can get fully pregnant and do constitutional carry for the whole country. And I don't think this is, by the way, it doesn't rely on the Commerce Clause, which H.R. 38 does. My amendment, which is a restatement of my national reciprocity bill, just says the Constitution says you have the right to keep and bear arms. There should not be two standards. Yeah, we'll let the states, as Heller described, the Heller decision, have some discretion in who can own what. But once you've established that standard, you can't have another standard for who can carry that thing. I mean, if you can own it, surely you should be able to carry it. And by the way, there's been a lot of discussion about is constitutional carry good or not? Well, there are 29 states that allow it now, and guess what? 2 of those states the legislature, both the House and the Senate in that state and the governor, are controlled by Democrats, and they've not repealed it. They've had every opportunity. They control all the levers of government in Vermont and Maine, and they have constitutional carry, and guess what? They decided to keep it. It can't be all that bad if the Democrats in those states are keeping it.
But would the gentleman yield?
No, I've got to introduce this bill. Furthermore, a recent study in Ohio's constitutional carry law conducted by the Center for Justice Research shows that after constitutional carry was enacted, the rate of crimes involving a firearm decreased in 6 of Ohio's 8 largest cities. And it doesn't have an appreciable effect on law enforcement injuries or deaths by firearms in Ohio's cities of interest. So, and finally, the states are recognizing this. We're at 29 states. Every year there's another state that joins the rolls of constitutional carry. It just makes sense. Over half the states have it. Instead of having a patchwork, let's just grant the same rights to everybody that the Constitution, the Second Amendment, has enshrined. With that, my time has expired, and I yield back.
Gentleman yields back. Who seeks recognition?
I'll insist on my point of order, Mr. Chairman.
Mr. Chairman,
Yep.
I'm sorry. I withdraw my amendment.
The point of order is not really germane now that the gentleman has withdrawn his amendment. Even though I liked his amendment. But I don't know that everyone in the conference will leave it at that. Who seeks recognition? The gentleman from New York is recognized.
I have an amendment at the desk.
Clerk will report. Gentleman from Arizona reserves a point of order.
Amendment to the amendment and the
Without
nature.
objection, the amendment will be considered as read. The gentleman from New York is recognized to explain his amendment.
Well, Mr. Massey, you are in luck because this amendment does exactly what you wanted to do, which is
I doubt that.
Which is to say that this bill does not apply to any individual who would not otherwise be able to possess a gun in the state in which to which they carry it. It is pretty simple, just is a pure federalism amendment. It says that the state laws of a particular state shall not be overruled by a different state law through a federal mandate of reciprocity. Very simple. Pure states' rights. I know my colleagues support states' rights. And the notion here that we should have the ability, as Mr. Massey just said, for someone in Kentucky to have far more lenient gun laws when that person travels to California than an individual in California obviously makes no sense. And I know Mr. Massey will agree with that. So this is a fairly simple amendment that ensures that states get to control who possesses a gun within their own state lines. So if you're not permitted to carry a firearm in a particular state, you cannot do an end run around that prohibition by getting a permit in a different state and crossing state lines. I would love for my colleagues on the other side of the aisle to explain to me why they are going to oppose this, and I know they are going to, but explain how it is consistent with federalism when what you are effectively saying is that your knowledge, your expertise, your wisdom, your judgment should supersede that of states who have control over their own gun licenses and gun rules. And with that, I yield back.
Gentleman yields back. I oppose the amendment from the gentleman from New York. It's not to say my judgment supersedes the judgment of the state. It's to say that the Second Amendment should apply to every single American who is a law-abiding citizen who's not disqualified under current law, and they should be able to exercise their rights and enjoy the fullness of their rights, regardless of whether they're on one side of a state line or the other. It applies to the American people, and that would be the reason why. This amendment just simply undermines the whole purpose of the bill, and for those reasons, I would oppose it.
Will the gentleman yield?
Yeah.
So are you saying then that any state that effectively the most lenient gun laws are what the Second Amendment in a particular state are what the Second Amendment requires, and that any more restrictive gun laws in any other state then violates the Second Amendment?
No, I'm simply saying that your Second Amendment rights don't end because you happen to cross a state line. Your Second Amendment rights are your Second Amendment rights. They apply to you as an American citizen. The plain and simple. And that is what this legislation is all about. It's why I said I like the amendment by offered by our colleague from Kentucky and then withdrawn, but this amendment would undermine the whole concept.
No, I understand that it might undermine the whole concept.
Not might, it would.
The problem is that the concept itself is preposterous. And this amendment gets to the point.
The Second Amendment is far from preposterous.
This is not about the Second Amendment.
I think the time belongs to me. The Second Amendment is far from preposterous. It is the Second Amendment. It is fundamental, and court decision after court decision has said that. You can't have, like,
Mr. Chairman, I didn't say the Second Amendment is preposterous.
I think I have the time.
Okay, but just don't
may issue versus
misquote
shall
me.
issue.
Don't misquote me. I didn't say the Second Amendment is preposterous. I said this bill is preposterous.
And I'm saying your amendment undermines the entire purpose of the Second Amendment, which applies to American citizens, American people, and that is why we oppose why I oppose the amendment. Who seeks recognition? I yield back. Who seeks recognition?
I do, Mr. Chairman.
The ranking member's recognition.
Thank you kindly, Mr. Chairman. Look, we need to sort out this problem with what is constitutionally required and what's not. Okay, so the Supreme Court struck down New York's law in the Bruin decision, saying that it was far too difficult. But they did not strike down all laws governing access to concealed carry. In fact, courts have been upholding laws with respect to concealed carry. So there's differences around the country. So that's where the realm of play is. But this law would wipe that out, all in the name of the Second Amendment, even though the court is not saying that the Second Amendment compels states to wipe out any laws with respect to concealed carry. So I'll give you an example. So some states have said that if you assault a police officer, and it's not an aggravated assault, say it's a simple assault of a police officer, but it's an assault. You hit a police officer, you attack a police officer, then you can't get concealed carry for either a period of years in some states or forever in some states. Now, other states say no, if it's a felonious assault against a cop, then you're not going to be able to get it. But if it's a misdemeanor assault, we're going to allow you to get concealed carry. Now, that's within the realm of the policy discretion of the states. But your bill would say that the states that allow misdemeanors against police officers to have concealed carry as a matter of right overwhelm and trump those states which say no. And nobody can explain why, other than to go back to the fallacy that the Second Amendment requires it. The Second Amendment doesn't require it, right? So, but one state could say, we think the First Amendment is so important that you're allowed to have rock music and bullhorns at 2 in the morning in front of people's houses. The Supreme Court has said that's not necessary. There can be reasonable time, place, manner restrictions that ban that, but if your state wants to do it, they can do it. But now you would say, by this analogy, let's take that most extreme permissive law and spread it all across the country. and say anybody can show up with a bullhorn and shout at somebody else in somebody else's state. So, I understand why the NRA supports this. I just don't know why we would support this. What we're looking for in America is reasonable, common sense, common ground gun safety legislation. And what this does is it opens up a gaping hole in a way that is being deplored by the police officers and their associations, saying, don't do this. Don't give people the right to cross state lines under the most permissive state laws in the country, carrying guns to all 50 states. And that's exactly what this does. And the gentleman's amendment puts the lie to the claim that this is about reciprocity. It's not about reciprocity. It's about wiping out and flattening the state laws of 50 states across the country. It's an attack on federalism. And you may choose to do it, but don't lie to yourselves. This has nothing to do with reciprocity, because you're crushing the state laws that have been chosen by the legislatures of the people in each of the states. They've chosen to define their laws in a particular way, and what we're saying is, no, we're going to flatten it out with a nationwide sledgehammer instead. So, the police officers are begging you not to do it. The gun safety groups are begging you not to do it. And yet it seems like it's full steam ahead. I want to speak strongly for Mr. Goldman's amendment. It doesn't completely wipe out the bill, as our good chairman just said, because all it says is that the state legislative choices of the particular legislature in a state are going to be honored and respected. And if a state doesn't mind what the other states are doing, that's reciprocity, right? Then that's real reciprocity. But you're not talking about reciprocity. You're talking about demolition of the legislative choices of the people of the particular states.
Will the gentleman yield?
Yes, by all means.
I would just add another element to why this is not gutting the bill, as the chairman said, which is this amendment does not address concealed carry. This amendment addresses laws that would prohibit the purchase or possession of a firearm in a particular state. So even with this amendment, if the concealed carry rules would allow for a permit in one state, those concealed carry rules under the statute that you have proposed here would still apply to other states, as long as that individual could lawfully possess that weapon. And as Mr. Massey was pointing out, there is a distinction between possession and carry, and this draws on that distinction.
Gentleman yields back. Gentleman from Maryland yields back. Question occurs on the amendment. The gentlelady, Ms. Crock, is recognized.
Thank you so much, Mr. Chair. And I can appreciate the conversation and engagement that's taken place. One thing that I haven't heard since I've been here is anyone read the actual language of the Second Amendment, and I may have missed it. But it's curious to me that it starts off with a well-regulated militia. And it seems like every time we get a bill, and I will read the whole thing, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. It starts off with a well-regulated militia, but every time we get a bill, it seems like that bill is all about getting rid of regulations. And it seems as if there's never a real conversation around why we need regulations in this country. And now we have states that have enacted laws. And if we were having a conversation about, say, reproductive rights, I'm sure y'all will be arguing and saying, oh, give it back to the states, give it back to the states. And so I don't understand why in this moment you don't want the states to be able to decide when literally the very first words are talking about regulation. With that, I will yield.
Gentlelady yields back. Question occurs on
I have a UC.
The gentleman from Arizona is recognized.
Yes, Mr. Chairman, I'd like to submit for the record the case of District of Columbia versus Heller, in which the Supreme Court said, there seems to us no doubt on the basis of both text and history that the Second Amendment conferred an individual right to keep and bear arms. And then I'll submit that, Mr. Chairman.
Without objection. The question occurs on the amendment offered by the gentleman from New York. All those in favor say aye. All those opposed, no. No. In the opinion of the chair, the noes have it.
Could we have a recorded vote?
Vote being requested, the clerk will call the roll.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Issa? Mr. Issa votes no. Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. Tiffany? Mr. Tiffany votes no. Mr. Massey? Mr. Roy? Mr. Roy votes no. Mr. Fitzgerald? Mr. Klein? Mr. Klein votes no. Mr. Gooden? Mr. Van Drew? Mr. Van Drew votes no. Mr. Nels? Mr. Moore? Mr. Moore votes no. Mr. Kiley? Ms. Hageman? Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Fry votes no. Mr. Grothman? Mr. Knott? Mr. Knott votes no. Mr. Harris? Mr. Onder? Mr. Onder votes no. Mr. Schmidt? Mr. Schmidt votes no. Mr. Gill? Mr. Gill? Mr. Gill votes no. Mr. Baumgartner? Mr. Baumgartner votes no. Mr. Raskin?
Aye.
Mr. Raskin votes aye. Mr. Nadler? Ms. Lofgren? Ms. Lofgren votes aye. Mr. Cohen? Mr. Johnson?
Aye.
Mr. Johnson votes aye. Mr. Swalwell? Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon? Ms. Scanlon votes aye. Mr. Nergoose? Ms. McBath? Ms. McBath votes aye. Ms. Ross? Ms. Ballant? Mr. Garcia? Mr. Garcia votes aye. Ms. Kamlager-Dove? Ms. Kamlager-Dove votes aye. Mr. Moskowitz? Mr. Goldman? Mr. Goldman votes aye. Ms. Crockett? Ms. Crockett votes aye. Mr. McClintock votes no. Mr. Fitzgerald, you are not recorded. Mr. Fitzgerald votes no. Mr. Grothman? Mr. Grothman votes no. Mr. Gooden? Mr. Gooden votes no.
Clerk will report.
Mr. Chairman, there are 9 ayes and 18 noes.
The amendment is not agreed to. Question is on the adoption.
Mr. Chairman, I've got an amendment at the desk.
Clerk will report.
Reserve.
Point of order reserved by the gentleman from California. Clerk will report the amendment.
Amendment to the amendment in the nature
Without
of...
objection, the amendment will be considered as read. Gentleman from Maryland is recognized to explain his amendment.
It's a simple one, Mr. Chairman. It essentially tries to make the language of the bill live up to the title of the bill. It's about honoring those states that have already engaged in reciprocity arrangements with other states. And it honors those and says that it doesn't apply to them. So for states that don't have that, it would continue to apply. But for states that have actually engaged in reciprocal arrangements with other states, we honor those. I submit it to the wisdom of our committee.
Chairman, I withdraw my reserve.
Point of order is withdrawn. The chair recognizes himself. I mean, I oppose the amendment. The idea is to give some uniformity, not to create this patchwork that I guess may exist now, does exist now. And this seems to me to water down what the legislation is intended to accomplish. And for those reasons, I would urge a no on the amendment. Who seeks rec? And I yield back. On the amendment offered by the ranking member, all those in favor say aye.
Aye.
Those opposed, no. No. In the opinion of the chair, the noes have it.
Could I request a recorded vote, please, Mr. Chairman?
Recorded vote. The clerk will call the roll.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Issa? Mr. Issa votes no. Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Mr. Tiffany? Mr. Tiffany votes no. Mr. Massey? Mr. Roy? Mr. Roy votes no. Mr. Fitzgerald? Mr. Klein? Mr. Klein votes no. Mr. Gooden? Mr. Gooden votes no. Mr. Van Drew? Mr. Van Drew votes no. Mr. Nels? Mr. Moore? Mr. Moore votes no. Mr. Kiley? Ms. Hageman? Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Fry votes no. Mr. Groffman? Mr. Groffman votes no. Mr. Knott?
No.
Mr. Knott votes no. Mr. Harris? Mr. Onder? Mr. Onder votes no. Mr. Schmidt? Mr. Schmidt votes no. Mr. Gill? Mr. Gill votes no. Mr. Baumgartner? Mr. Baumgartner votes no. Mr. Raskin?
No.
Mr. Raskin votes no.
Oh, I'm sorry, I vote aye. I'm mistaken.
Mr. Raskin votes aye. Mr. Nadler? Ms. Lofgren?
Compelling argument.
Ms. Lofgren votes aye. Mr. Cohen? Mr. Johnson? Mr. Swalwell? Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon? Ms. Scanlon votes aye. Mr. Neguse? Ms. McBath? Ms. McBath votes aye. Ms. Ross? Ms. Ballant? Ms. Ballant votes aye. Mr. Garcia? Mr. Garcia votes aye. Ms. Kamlager-Dove? Ms. Kamlager-Dove votes aye. Mr. Moskowitz? Mr. Goldman? Mr. Goldman votes aye. Ms. Crockett?
Aye.
Ms. Crockett votes aye.
Gentleman from Wisconsin.
Mr. Fitzgerald, you are not recorded. Mr. Fitzgerald votes no.
Mr. Chair, point of information.
Young lady from Texas.
Is there any reason we don't vote electronically?
Yes, there's a reason. Let's finish the vote here, and then we can come back.
We finished the vote. What's the reason?
Clerk will report.
Mr. Chairman, there are 9 ayes and 18 noes.
The amendment is not agreed to. The question.
Mr. Chair, now that we finished the vote, I'm just thinking, because I know we've been talking about efficiency in government, and we have the technology.
Yes,
And
we
so
do.
this, you know, we appreciate our clerk, and our clerk would still have a job for sure. But
The tradition of the Judiciary Committee is to deal with the amendments when presented at the time, not to roll votes and vote electronically. I guess we could have electronic votes at the time,
Yes.
but we don't operate like the other committee I'm on. The committee Mr. Raskin came from, the Oversight Committee, where they roll votes.
But is it
And
possible? Is it possible for us to, even these votes that we're doing,
understand.
is that something we can discuss?
We could.
Mr. Chairman? Mr. Chairman?
Mr. Chairman, I'd like regular order.
Yeah.
Mr. Chairman?
We could discuss it, but
A point of order, Mr. Chairman.
Gentlelady from
The
California.
Science Committee actually has electronic voting, and we
I
would be
understand.
happy to share that with the committee.
I understand, a number of committees do, but the Judiciary Committee does not and probably will not have it, at least this Congress. The question is on the adoption of the amendment, the nature of a substitute. This will be followed immediately by a vote on reporting the bill. All those in favor say aye. Aye. Those opposed, no.
No.
In the opinion of the chair, the ayes have it. The amendment, the nature of a substitute, is adopted. The question is on favorably reporting the bill as amended. All those in favor say aye. Aye. Those opposed, no.
No.
The ayes have it, and the bill is ordered to be reported favorably to the House.
Can we have a recorded vote, please?
I assume you were going to ask that, so the clerk will call the roll.
Mr. Jordan?
Manually, yes.
Mr. Jordan?
Yes.
Mr. Jordan votes yes. Mr. Isa? Mr. Isa votes yes. Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock? Mr. McClintock votes aye. Mr. Tiffany? Mr. Tiffany votes aye. Mr. Massey? Mr. Roy? Mr. Roy votes aye. Mr. Fitzgerald? Mr. Klein? Mr. Klein votes aye. Mr. Gooden? Mr. Gooden votes aye. Mr. Van Drew? Mr. Van Drew votes aye. Mr. Nels? Mr. Moore? Mr. Moore votes aye. Mr. Kiley? Ms. Hageman? Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Fry votes aye. Mr. Grothman? Mr. Grothman votes aye. Mr. Knott?
Aye.
Mr. Knott votes aye. Mr. Harris? Mr. Onder? Mr. Onder votes aye. Mr. Schmidt? Mr. Schmidt votes aye. Mr. Gill? Mr. Gill votes aye. Mr. Baumgartner? Mr. Baumgartner votes yes. Mr. Raskin? Mr. Raskin?
No.
Mr. Raskin votes no. Mr. Nadler? Ms. Lofgren? Ms. Lofgren votes no. Mr. Cohen? Mr. Johnson? Mr. Swalwell? Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon? Ms. Scanlon votes no. Mr. Neguse? Ms. McBath? Ms. McBath votes no. Ms. Ross? Ms. Ballant? Ms. Ballant votes no. Mr. Garcia? Mr. Garcia votes no. Ms. Kamlager-Dove? Ms. Kamlager-Dove votes no. Mr. Moskowitz? Mr. Goldman? Mr. Goldman votes no. Ms. Crockett? Ms. Crockett votes no. Mr. Fitzgerald, you're not recorded. Mr. Fitzgerald votes aye.
Clerk will report.
Mr. Chairman, there are 18 ayes and 9 noes.
The ayes have it, and the bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute, incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I call up H.R. 2184, the Firearm Due Process Protection Act, for purpose of markup, and move that the committee reported favorably to the House. The clerk will report the bill.
H.R. 2184.
Without objection, the bill will be considered as read. The chair is recognized for an opening statement. The Firearm Due